Hello, everybody. I'm delighted to be with you today to talk about Hong Kong's regulatory regime for virtual asset trading platforms, that's crypto exchanges, and the most recent developments in this area. During the course of today's webinar, I'm first going to describe in some detail Hong Kong's licensing regime for virtual asset trading platforms. That will cover the scope of activities that need to be licensed, the various requirements that must be met for platforms to become licensed, their ongoing obligations, and the various restrictions on their activities once they become licensed. And lastly, the statutory offences that cover misconduct involving virtual assets. After that, I will move on to cover some of the latest developments, including the scandal involving unlicensed crypto exchange JPEX, which I think demonstrates why this space should be regulated. Hong Kong has two licensing regimes governing trading platforms. Under Part 5B of the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, which I'll refer to as the AMLO, which came into effect on the 1st of June 2023, all platforms that offer trading in virtual assets that are not securities within the definition set out in Schedule 1 to the Securities and Futures Ordinance, for example, Bitcoin, must be licensed by the SFC. Platforms that provide trading in virtual assets that are securities under the SFO, on the other hand, need to be licensed under the SFO for regulated activities, Type 1, that's dealing in securities, and Type 7, providing automated trading services. Given the possibility of a virtual asset regulatory classification changing from a non-security to a security and vice versa, the SFC is encouraging virtual asset trading platforms and relevant employees to apply for licenses under both ordinances. Applicants for dual licensing can submit a single consolidated application online through the SFC's Wings platform, indicating that they are simultaneously applying for both licenses. According to the SFC's website, there are currently only two licensed virtual asset trading platforms, OSL Digital Securities Limited and Hash Blockchain Limited. Both platforms were already licensed by the SFC to trade virtual assets that are securities under the SFO licensing regime before the AMLO regime came into effect. The SFC has now licensed them under the AMLO to allow them to offer trading in non-security virtual assets. The SFC has not yet approved any of the licensing applications submitted since 1st June 2023, when the AMLO licensing regime took effect, but there are currently 17 trading platforms waiting for their licensing applications to be approved. The implementation of the new AMLO licensing regime means that Hong Kong now complies with certain requirements of the Financial Action Task Force, which I'll refer to as FATF, which is the International Anti-Money Laundering Watchdog. Very briefly, under FATF's interpretive note to FATF Recommendation 15, FATF member jurisdictions, which include Hong Kong, should require virtual asset service providers, commonly referred to as VASPs, to be licensed or registered by a competent authority, which must regulate VASPs in relation to anti-money laundering and counter-terrorist financing, and monitor their compliance with AML and CTF regulations. FATF also requires countries to apply the so-called travel rule to virtual asset transfers. This requires originating VASPs to obtain and hold accurate required originator information and required beneficiary information on virtual asset transfers, and to submit that information to any beneficiary VASP or financial institution and make it available on request to appropriate authorities. FATF compliance was one of the drivers behind Hong Kong's implementation of its regulatory regime for virtual asset trading platforms. Non-compliance would risk Hong Kong being placed on the FATF's grey list of non-compliant jurisdictions. The implementation of Hong Kong's new licensing regime also aligns with the Hong Kong government's stated objective of developing Hong Kong as an international hub for Web3 and virtual assets. In April 2023, ahead of the implementation of the new AMLO licensing regime, the Hong Kong Monetary Authority issued a circular to Hong Kong banks, urging them to provide banking services to SFC-licensed virtual asset trading platforms to support what it described as their legitimate need for bank accounts. This was seen as a move aimed at supporting the government's objectives and countering banks' reluctance to open bank accounts for crypto-related businesses. The requirements for licensing virtual asset trading platforms are, however, stringent, and licensed platforms are subject to various continuing obligations, including additional obligations for platforms serving retail investors and individual professional investors. Hong Kong's implementation of a regulatory regime for crypto exchanges is also viewed as having created a degree of regulatory clarity in comparison with the US, where regulation is implemented through enforcement actions rather than legislation. Crypto regulation in the US is currently mired in a turf war between the securities regulator, the SEC, and the commodities regulator, the Commodity Futures Trading Commission. According to a Bloomberg article, Hong Kong, as well as Singapore, South Korea, and Japan, which also have crypto regulatory regimes in place, are expected to benefit from crypto exchanges moving out of the US, although, of course, this is a dynamic space with many ongoing developments. As I'll talk about later, the SFC has taken a number of initiatives to try and improve investors' understanding of the risks associated with regulated and unregulated platforms in the wake of the scandal involving unlicensed trading platform JPEX in 2023. The actions of the Hong Kong police in arresting a number of individuals involved was a clear signal that action will be taken against anyone who breaches the regulatory regime. The regulators are clearly determined to prevent the JPEX case and other more recent cases from damaging Hong Kong's ambitions as an international crypto hub. Hong Kong's desire to establish itself as a crypto hub is part of the government's wider efforts to establish the city as a cutting-edge financial centre. Financial Secretary Paul Chan referred to virtual assets as unstoppable new financial innovations that Hong Kong needs to embrace, while the HKMA's FinTech Promotion Roadmap sets out its vision of bolstering Hong Kong's position as a leading global financial centre, offering world-class digitally enabled products and services. In building its regulatory regime, Hong Kong has had the advantage of seeing what has gone wrong in other jurisdictions, for example, in the case of failed US-based crypto exchange FTX, and building provisions into its regulatory regime to prohibit regulated platforms from engaging in the types of activities that put investors' assets at risk, such as lending client virtual assets. While it's true that JPEX failed in Hong Kong, JPEX was not a licensed platform. If anything, its activities make the case for stringent regulation of virtual asset trading platforms and strict enforcement of the regulatory regime against those who breach its provisions. Looking first at the licensing regime under the AMLO, an entity is required to be licensed if it carries on a business of providing a virtual asset service, which the AMLO refers to as a VA service in Hong Kong, or holds itself out as doing so. Licensing under the AMLO is also required for an offshore entity to actively market, either itself or through another person, to the Hong Kong public any service that it provides outside Hong Kong, which would be a VA service if it were provided in Hong Kong. So an offshore entity that actively markets to the Hong Kong public a VA service that it provides offshore is required to be licensed. The relevant provision is Section 53ZRB3 of the AMLO, and it's the equivalent of Section 115 of the SFO, which applies to securities. In practice, however, the SFC will not license offshore entities since they fall beyond its regulatory remit. The provision therefore operates to prohibit any offshore VA trading platform from actively marketing its VA trading services to the Hong Kong public. Failure to comply with the AMLO's licensing regime is an offence which carries maximum penalties of 7 years imprisonment, a Hong Kong $5 million fine, and a daily fine of 100,000 Hong Kong dollars for continuing offences. As to what amounts to active marketing for the purposes of Section 537RD, the SFC's FAQ states that examples of active marketing include frequently calling on Hong Kong investors to market services, including offering products and mass media programs and internet activities targeting Hong Kong investors. The FAQ lists various non-exhaustive factors it will consider in determining whether services are actively marketed to the Hong Kong public. These include whether there's a detailed plan to promote the services, whether the services are extensively advertised, using direct mailing, advertisements in local newspapers or broadcasting, or push technology over the internet, and whether the services are packaged to target the Hong Kong public, for example, by being written in Chinese and denominated in Hong Kong dollars. However, we need to be cautious in relying on that interpretation, since the SFC argued against its own interpretation in the case of Ng Chiu Moi against the SFC, when it asserted that the term meant no more than marketing in the primary sense of proactively advertising the service to the Hong Kong public. The meaning of the term active marketing was not determined in the case, since the services had been extensively advertised in local newspapers. Turning now to what constitutes providing a VA service, the AMLO defines this as operating a VA exchange, which is in turn defined as providing services through means of electronic facilities, whereby offers to sell or purchase virtual assets are regularly made or accepted in a way that forms or results in a binding transaction, or persons are regularly introduced or identified to other persons in order that they may negotiate or conclude, or with the reasonable expectation that they will negotiate or conclude, sales or purchases of virtual assets in a way that forms or results in a binding transaction. The licensing regime therefore applies to virtual asset trading platforms that operate in Hong Kong or whose offshore services are actively marketed to the Hong Kong public. The SFC has said that the VATP licensing regime applies only to centralized VA trading platforms that provide virtual asset trading services to clients using an automated trading engine, which matches client orders and also provide custody services as an ancillary service to their trading services. The provision of virtual asset services without an automated trading engine and ancillary custody services, for instance, over-the-counter virtual asset trading activities and virtual asset brokerage activities, does not require a license. The Hong Kong licensing regime therefore only covers centralized crypto exchanges at the moment. However, the Hong Kong regulators are proposing to introduce a licensing regime for providers of over-the-counter trading of virtual assets, as there have been several cases where so-called VA OTC shops have allegedly provided services to retail investors and made false or misleading claims about their license status. The FSTB conducted a public consultation on its proposed regulatory regime for OT services earlier this year, although it's not yet published the conclusions to that consultation. It's worth noting that the scope of Hong Kong's regulation of virtual asset activities is narrower than required under the FATF recommendations, under which the businesses that are required to be licensed or registered as VASPs also include businesses that are involved in the safekeeping of virtual assets or instruments creating control over virtual assets, that is, cryptographic keys. This would require the licensing of crypto custodians and custodians of cryptographic keys. The FATF VASP definition also covers businesses involved in the transfer of virtual assets, such as virtual asset payment businesses. When the consultation on the new AMLO regime was conducted, the FSTB explained that it had decided to only regulate crypto exchanges as they were the predominant crypto-related businesses in Hong Kong. The number of standalone crypto custodian and crypto payment businesses in Hong Kong at the time was negligible. However, the AMLO gives the Secretary for Financial Services and the Treasury the power to amend the definition of VA service by notice published in the Gazette. The government may therefore choose to extend the scope of the licensing regime in the future if it sees fit. Virtual assets are defined in Section 537RA of the AMLO. There are three strands to the definition. First, the virtual asset must be a cryptographically secured digital representation of value that's expressed as a unit of account or a store of economic value. Secondly, the virtual asset must either be used or intended to be used as a medium of exchange accepted by the public for the payment of goods or services, for the discharge of a debt and/or for investment, or must provide rights, eligibility, or access to vote on the management, administration, or governance of the affairs in connection with or to vote on any change of the terms of any arrangement applicable to any cryptographically secured digital representation of value. The third strand of the definition is that the virtual asset must be transferred, stored, or traded electronically. This definition includes Bitcoin, altcoins, and stablecoins, although the SFC has said that stablecoins should not be admitted for trading by retail investors until they're regulated in Hong Kong. As you may be aware, the FSTB and the HKMA recently published the consultation conclusions to their proposals to introduce a licensing regime for the issuers of fiat-referenced stablecoins. However, no date has yet been set as to when the regime will come into force. There are a number of specific exclusions from the virtual asset definition. It excludes digital representations of fiat currencies, central bank digital currencies, financial assets already regulated under the SFO, such as securities and futures contracts, and stored value facilities, which are separately regulated under the Payment Systems and Stored Value Facilities Ordinance. The definition also excludes limited purpose digital tokens, which include non-transferable, non-exchangeable, and non-fungible closed-loop limited purpose items, such as air miles, credit card awards, gift cards, customer loyalty programs, and gaming coins. As to the licensing regime under the SFO, virtual asset trading platforms that provide trading in virtual assets that are securities within the SFO definition and provide automated trading services in those virtual assets, or hold themselves out as doing so, need to be licensed under the SFO for regulated activities type 1, that's dealing in securities, and type 7, that's providing automated trading services. As is the case for the AMLO licensing regime, the SFC has indicated that licensing is required only for centralized virtual asset trading platforms. That's trading platforms that provide trading, clearing, and settlement services for virtual assets and have control of client assets. The SFC does not license platforms which provide peer-to-peer trading in virtual assets between clients, where the trades take place off exchange and the clients retain custody of their virtual assets. As is the case under the AMLO, the SFL also prohibits an offshore entity from actively marketing to the Hong Kong public any services it offers offshore that would constitute SFO-regulated activities if they were provided in Hong Kong under Section 115 of the SFO. That prohibition applies whether the offshore entity conducts the active marketing itself or through another person, and whether the active marketing is conducted from offshore or in Hong Kong. The provision means that offshore virtual asset trading platforms cannot actively market their offshore services to the Hong Kong public. What constitutes active marketing is the same under the AMLO and the SFO. While the AMLO and SFO set out the key regulatory provisions for VA trading platforms, the detailed obligations and requirements are set out in various SFC codes, guidelines, and FAQs. Many of the detailed obligations on VA trading platforms are set out in the SFC's guidelines for VATP trading platforms. The SFC has also issued a guideline on anti-money laundering and counter-financing of terrorism for licensed corporations and SFC licensed virtual asset service providers, and a prevention of money laundering and terrorist financing guideline for associated entities of these corporations, as well as FAQs on licensing matters and on conduct-related matters. Looking now at the eligibility requirements for licensing, Hong Kong incorporated companies that have a permanent place of business in Hong Kong and overseas companies that are registered in Hong Kong under the Hong Kong Companies Ordinance are eligible for licensing under the AMLO and SFO licensing regimes. Businesses that do not have a separate legal personality, such as partnerships and sole traders, individuals, and overseas companies that are not registered in Hong Kong, are not eligible to be licensed as VA trading platforms in Hong Kong. An entity applying to be licensed must be fit and proper, which means that it must not be subject to any receivership, administration, liquidation, or other similar proceedings, have failed to meet any judgment debt, or be unable to meet any financial or capital requirements that apply to it. The VATP guidelines set out financial resources requirements that licensed platform operators must meet on a continuing basis. First, they must have at least 5 million Hong Kong dollars of paid up share capital and liquid capital of the higher amount of 3 million Hong Kong dollars and the basic amount as defined in Division 2 of Part 4 of the Securities and Futures Financial Resources Rules. They are also required to be beneficially own assets that are sufficiently liquid, such as cash, deposits, treasury bills, and certificates of deposit, but not virtual assets, that are equivalent to at least 12 months of their actual operating expenses, calculated on a rolling basis. The SFC also needs to be satisfied as to the competency of the VA trading platform operator and will consider various key elements, including its business model, corporate governance, internal controls, operational review, risk management, and compliance, in addition to the combined competence of its senior management and other staff members. A license applicant will need to have a clear business model detailing its modus operandi and target clientele, as well as written policies and procedures to ensure continuous compliance with the relevant legal and regulatory requirements. The applicant has to demonstrate to the SFC that it has a proper business structure good internal control systems, and qualified personnel to ensure the proper management of the risks it will encounter, carrying on its proposed business as detailed in its business plan. Licensing applicants need to include detailed information on these points in their business plan, compliance manual, and other internal policies and procedures. Platform operators need to appoint a minimum of 2 responsible officers to supervise their licensed business, who must be approved by the SFC. The main requirements for responsible officers are that at least one responsible officer must also be an executive director of the company, and if the company has more than one executive director, they must all be appointed as responsible officers. In addition, at least one responsible officer must be ordinarily resident in Hong Kong, and at least one responsible officer must be available at all times to supervise each regulated activity or business. Where a platform is dual licensed under the AMLO and SFO, it's required to have 2 rather than 4 duly licensed responsible officers to meet the minimum statutory requirement for 2 responsible officers under each ordinance. The SFC states in its licensing handbook for VATP operators that it will only license overseas residents if they come to Hong Kong to conduct regulated activities on behalf of a licensed platform operator to which they're accredited. It will not license to individuals who only conduct business activities outside Hong Kong. If a responsible officer will be stationed overseas and will visit Hong Kong from time to conduct regulated activities, the SFC will impose a non-sole condition on the responsible officer's license. The non-sole condition means that when the responsible officer actively participates in or supervises the platform's licensed business, they must do so under the advice of another responsible officer who's not subject to the non-sole condition. However, itinerant professionals who will only spend short periods in Hong Kong for specific purposes should not be appointed as responsible officers because this is incompatible with their responsibilities for supervising the virtual asset trading platform's business. The SFC has also said that responsible officers must participate in supervising the platform's regulated activities and that licensed platforms should not hire individuals who act as responsible officers in name only and have no real supervisory role. Responsible officers need to be fit and proper persons to act in this capacity. The fact is relevant to the SFC's assessment of an individual's fitness and properness to be a responsible officer include their financial status and solvency, their educational or other qualifications and experience, their ability to carry on regulated activities competently, honestly, and fairly, and their reputation, character, reliability, and financial integrity. The SFC will also take into account a person's convictions for offences under the AMLO, the United Nations Anti-Terrorism Measures Ordinance, the Drug Trafficking Recovery of Proceeds Ordinance, or the Organised and Serious Crimes Ordinance, and comparable offshore convictions, as well as a person's previous breaches of the AMLO. The SFC's VATP guidelines set out the SFC's requirements in terms of responsible officers' academic or professional qualifications, relevant industry experience, recognised industry qualifications, management experience, and the Hong Kong Securities Institute papers they're required to have passed. There are 3 routes to meeting these requirements. If a person has a relevant university degree, that's a degree in accounting, business administration, economics, finance, law, or internationally recognized professional qualifications in those subjects, they must also have at least 3 years direct relevant industry experience acquired in the previous 6 years, 2 years management experience, and have passed Hong Kong Securities Institute papers 1 and 2. Individuals who have degrees in other subjects are required to have at least 3 years direct relevant industry experience over the previous 6 years. 2 years management experience, have passed HKSI papers 1 and 2, and have either passed Hong Kong Securities Institute papers 7 and 8, or completed an additional 5 hours of continuous professional training within the 6 months before they apply to be licensed. The final route is for individuals who have attained level 2 in either English or Chinese and maths in the Hong Kong Diploma of Secondary Education exams or equivalent overseas qualifications. These people are required to have 2 years of management experience and to have passed HKSI papers 1 and 2. They also need direct relevant industry experience of 3 years over the previous 6 years or 5 years over the previous 8 years. They additionally need to have passed HKSI papers 7 and 8 or to have completed an additional 5 hours of continuous professional training in the 6 months before they apply to be licensed. The SFC will recognize an individual's industry experience as direct relevant industry experience if they were a key person involved in the development or in ensuring the proper functioning of a technology, platform, or system that's central to the virtual asset trading platform for which the person will be a responsible officer. Merely providing system support, on the other hand, will not be recognized as relevant industry experience. Where responsible officers' applicants' industry experience largely relates to non-security virtual assets, and the person has no experience of dealing in securities or vice versa, the SFC has said that it is prepared to be flexible, given that this is a new industry. That's to say, it will consider industry experience dealing in non-security virtual assets as industry experience relevant to Type 1 dealing in securities regulated activity under the SFO, although it will impose a licensing condition on the person's Type 1 license that they can only provide Type 1 regulated activity services for the business of an SFC licensed platform operator. Also, it will recognize industry experience of dealing in securities as industry experience relevant to providing a VA service under the AMLO, but it will impose a non-sole condition on the responsible officer's license to provide a VA service. This arrangement is intended as a temporary measure, which has been adopted for pragmatic reasons due to a lack of talent with both virtual asset and securities related experience at this early stage. The SFC will review whether this provision needs to be retained as the market develops. In terms of what the SFC will recognize as management experience, this needs to be hands-on experience of supervising and managing the business regulated functions in a business setting. Managing the platform's staff who conducted the regulated functions or engaged in its projects can also be regarded as management experience. Under the VATP guidelines, the SFC will also accept management experience gained in the financial industry, unless it is purely administrative, for example, involving human resources or office administration. Individuals who will provide regulated services on behalf of a VA trading platform, including its responsible officers, need to be licensed by the SFC as licensed representatives accredited to the VA trading platform. In practice, licensed representatives and responsible officer applications can be submitted simultaneously. Licensed representatives can only act for the platform operator to which they're accredited for conducting regulated activities. If a licensed representative ceases to act for their principal, the principal must notify the SFC through WINGS within 7 business days. The licensed representative can then apply for a transfer of their accreditation to another platform operator within 180 days. If a licensed representative has previously received a regulatory warning, this must be disclosed in the application form. The SFC expects individuals applying to be licensed representatives to have a basic understanding of the market and of the relevant legal and regulatory requirements. Again, there are 3 different routes to licensing. An individual with a relevant degree or professional qualification only needs to have passed HKSI Paper 1. Individuals with other degrees need to have passed Paper 1 and have at least 2 years relevant industry experience over the past 5 years, or have either passed HKSI Papers 7 and 8 or completed an additional 5 hours of continuous professional training within the 6 months before they apply to be licensed. The third route to licensing requires individuals with level 2 in English or Chinese and maths, again in the Hong Kong Diploma of Secondary Education exams or equivalent, to have passed Papers 1 and have 2 years of relevant industry experience over the previous 5 years. They also need to have completed 5 hours additional continuous professional training in the 6 months before applying for licensing, or have passed HKSI Papers 7 and 8. The substantial shareholders and ultimate owners of a VA trading platform operator are also required to be fit and proper and must be approved in writing by the SFC. A substantial shareholder is a person who has an interest of 10% or more in the platform operator's issued shares, or a person with an interest in the platform operator's shares, which entitles them, either alone or with their associates, to control the exercise directly or indirectly of 10% or more of the voting power at its general meetings. A person will also be a substantial shareholder of a VA trading platform operator if they hold shares in another company which entitles them, alone or with their associates, to control the exercise of 35% or more of the voting power at general meetings of that company, or of a further company which can exercise, either alone or with its associates, 10% of the voting power at general meetings of the platform operator. An ultimate owner is an individual who owns or controls more than 25% of the issued share capital of the VA trading platform operator, controls more than 25% of the voting rights at its general meetings, or controls its management. The factors that the SFC takes into consideration in determining whether a person is fit and proper include the person's financial status or solvency, their educational or other qualifications and experience, evidence of their competence, honesty, and financial integrity, their conviction in Hong Kong or elsewhere for any money laundering or terrorist financing offence or other offence involving fraudulent, corrupt, or dishonest conduct, and failure to comply with the AML CTF obligations or other obligations of licensed VA trading platforms. Any person who proposes to become an ultimate owner of a licensed VA trading platform must be approved in writing by the SFC. The SFC needs to be satisfied that the platform will continue to be fit and proper if the ultimate owner is approved. In granting its approval, the SFC can impose conditions on the licensed trading platform or the ultimate owner. A person who becomes the ultimate owner of a VA trading platform without the SFC's approval, without a reasonable excuse, will commit an offence for which the maximum penalty is a 1 million Hong Kong dollar fine and 2 years imprisonment, and a further fine of 5,000 Hong Kong dollars for every day that the offence continues. The SFC has also introduced a managers in charge of core functions regime for licensed virtual asset trading platform operators, the details of which are set out in the SFC's FAQs on measures for augmenting senior management accountability in platform operators, which are based on the manager in charge regime applicable to other SFC licensed entities. The purpose of the regime is to implement the requirement for the trading platform's senior management to assume primary responsibility for ensuring that the platform has appropriate standards of conduct and that those standards are adhered to. Licensed VA trading platform operators need to appoint one or more managers in charge as individuals who are principally responsible, either alone or with others, for managing each of the platform operator's core functions. There are 8 core functions, the first of which is overall management oversight, which involves responsibility for the day-to-day direction and oversight of the effective management of the platform operator's overall operations. The manager in charge of this function could, for example, be the trading platform's chief executive officer or president. The person's main responsibilities include developing the platform operator's business model, objectives, strategies, organizational structure, controls and policies, developing and promoting sound corporate governance practices, culture and ethics, and executing and monitoring implementation of board-approved business objectives, strategies and plans, and the effectiveness of the organizational structures and controls. The second core function is key business line, which involves directing and overseeing a line of business comprising one or more types of SFO regulated activity and or a VA service under the AMLO. Examples of job titles of individuals the SFC gives for persons suited for this role are the head of automated trading services, head of brokerage services, or head of sales. The third of the core functions is operational control and review, which is responsible for the establishment and maintenance of adequate and effective systems of controls over the platform operations and reviewing the platform operator's compliance with and the adequacy and effectiveness of its internal control systems. The manager in charge of this function could, for example, be the chief operating officer, head of operations, or head of internal audit. The fourth core function is risk management, which involves responsibility for identifying, assessing, monitoring, and reporting risks arising from the platform operator's operations. Examples of individuals who could perform the role are the chief risk officer or head of risk management. The fifth core function is finance and accounting, which involves responsibility for ensuring timely and accurate financial reporting and analyses of the platform operator's operational results and financial positions. The manager in charge could, for example, be the chief finance officer, financial controller, or finance director. Sixth among the core functions is information technology, which relates to the design, development, operation, and maintenance of the platform operator's computer systems. A suitable person to be the manager in charge could be the chief information officer or head of information technology. Compliance is the seventh core function, for which the manager in charge could be the chief compliance officer or head of legal and compliance. That function is responsible for setting policies and procedures for complying with the legal and regulatory requirements in the jurisdictions in which the platform operator operates. Monitoring the platform operator's compliance with its policies and procedures, and reporting on compliance matters to the board and senior management. AMLO is the eighth core function and relates to establishing and maintaining internal control procedures to prevent the platform operator being involved in money laundering and terrorist financing. The manager in charge could be the head of financial crime prevention or head of compliance. These job titles are given by way of example only, and other people with sufficient seniority and experience could be appointed. The managers in charge of the overall management oversight and key business line functions are generally required to be responsible officers of the activities they oversee. They can be located offshore provided they're accountable to the platform operator. The board of a licensed platform operator needs to ensure that each manager in charge acknowledges their appointment as manager in charge and the particular core functions for which they're primarily responsible. Any change in managers in charge must be notified to the SFC within 7 business days of the change. Virtual asset trading platform operators also have to appoint a complaints officer to deal with complaints made to the platform operator, and an emergency contact person to be contacted by the SFC in the case of a market emergency or other urgent matter. These individuals don't need to be licensed. Applicants for licensing as a VA trading platform operator also have to obtain the SFC's approval of the premises they will use for keeping records or documents required to be kept under the Securities and Futures Keeping of Records rules and the VATP guidelines. The premises must be non-domestic premises which are suitable for storing the relevant documents and records. The SFC will normally only approve premises that are located in Hong Kong. One of the reasons for this is that a Hong Kong location is necessary to enable the SFC to exercise its power to enter premises to inspect a VA trading platform operator's records. To apply for licensing, applicants need to submit Form 1, the corporation's license application, Form 5, the new license application for licensed representatives and ROs for at least 2 proposed ROs, Questionnaire 1, the general business profile and internal control summary, Questionnaire 2 for VA trading platform operators, the first external assessment report, and the license application fee. Application forms, supplements, and questionnaires should be submitted to the SFC through Wings LIC. Applicants for VA trading platform licenses have to engage an external assessor to assess their business and submit 2 assessors' reports to the SFC. Different external assessors can be appointed to review different areas of an applicant's business. External assessors are expected to be independent. That's to say that service providers for the system used by a licensed applicant should not be appointed as the external assessor of that system. The external assessor's Phase 1 report needs to be submitted with the trading platform's license application. The areas of assessment include the design effectiveness of the VA trading platform's proposed structure, governance, operations, systems, and controls, with a focus on key areas such as governance and staffing, token admission, custody of virtual assets, KYC, AML, CTF, market surveillance, risk management, and cybersecurity. The external assessor's Phase 2 report must be submitted after the SFC grants approval in principle of the license. This report needs to assess the effectiveness and implementation of the policies, procedures, systems, and controls adopted by the license applicant. Any deviation from the planned policies and procedures must be clearly set out and explained. The areas covered by the second assessment include verification and confirmation that all external service providers, such as providers of market surveillance tools, AML, CTF tools, and KYC tools, have been engaged, and that the systems provided by them are fully adopted as planned and are in operation. It's also required to cover the conduct of a vulnerability assessment to identify, rank, and report potential vulnerabilities that may compromise a system, and should include internal and external vulnerability scans, as well as the performance of penetration tests on network devices, firewalls, servers, databases, wallets, and web applications to identify any vulnerabilities or potential issues. The Phase 2 report must also confirm that major or critical rectification steps have been taken for all medium to high risk items identified in the penetration and vulnerability tests. The SFC will only grant its final licensing approval when it's satisfied with the findings of the Phase 2 report. VA trading platform operators need to submit their bank account details to the SFC before their licensing application is approved. As I mentioned earlier, the HKMA issued a circular to Hong Kong's banks in April 2023, urging them to provide banking services to SFC-licensed virtual asset trading platforms. Supporting the Hong Kong government's push to become a global Web3 and crypto hub, the HKMA circular urges banks to adopt a forward-looking approach and strengthen their understanding of new and developing sectors and a risk-based approach rather than a wholesale de-risking approach. The circular also confirmed that the additional CDD measures for VATPs set out in the HKMA circular, regulatory approaches to authorized institutions interface with virtual assets and virtual asset service providers of the 28th January 2022 apply only when banks offer correspondent services, for example, an account to settle clients' transactions to overseas VATPs. In other words, the additional CDD measures are not required for SFC-licensed VA trading platforms. It also said that banks can consider opening an account once a VA trading platform applicant has received the SFC's approval in principle of its license application, rather than insisting on waiting until the actual grant of the license. According to the VATP licensing handbook and the SFC's FAQs on the SFC regulatory sandbox on becoming licensed, virtual asset trading platform operators will enter the SFC regulatory sandbox to allow the SFC to assess and monitor their delivery of services and internal control systems. The SFC expects this to facilitate dialogue between the SFC and VA trading platform operators, enabling platform operators to identify and address any risks arising from their activities. If the SFC decides to refuse a licensing application, the applicant will be given the opportunity to be heard, and the SFC will consider the applicant's representations before making a final decision. If the SFC then proceeds to refuse the application, the applicant has a right to apply for a review of its decision to the Anti-Money Laundering and Counter-Terrorist Financing Review Tribunal and the Securities and Futures Appeals Tribunal. The licenses of VA trading platform operators are granted subject to a number of licensing conditions. These include requirements that the platform operator must comply with the VATP guidelines and must immediately notify the SFC and cease operating a VA trading platform if it becomes aware that it cannot maintain or ascertain whether it maintains the required amounts of liquid capital and paid-up share capital. The licensing conditions also require VA trading platforms to provide the SFC with monthly reports on their business activities within 2 weeks of the end of each calendar month and any other information requested by the SFC. Licensed platforms must also engage an independent professional firm acceptable to the SFC to conduct an annual review of their activities and operations and prepare a report confirming that they have complied with the licensing conditions and all relevant legal and regulatory requirements. The first report must be submitted within 18 months of the approval of the platform operator's license. Subsequent reports are required to be submitted within 4 months of the end of each financial year and upon request by the SFC. Under the licensing conditions, VA trading platforms must obtain the SFC's written approval before introducing or offering a new or incidental service or activity or making a material change to an existing service or activity, including the long suspension or termination of an existing service or activity. The licensing conditions also restrict trading platforms to operating a centralized online virtual asset trading platform for trading of virtual assets on its platform and carrying on off-platform virtual asset trading business and incidental services provided by it to clients and activities conducted in relation to that off-platform business. SFC licensed VA trading platform operators are required to set up a token admission and review committee, which must be made up of members of senior management who are principally responsible for managing the key business line, compliance, risk management, and information technology functions. The SFC expects members principally responsible for the various functions to include the corresponding managers in charge of the platform operator. The responsibilities of the Token Admission and Review Committee include establishing, implementing, and enforcing the criteria for admitting, suspending, and withdrawing virtual assets for or from trading and the rules containing the obligations and restrictions on virtual assets. The committee is also responsible for making the final decision as whether to admit, suspend, and withdraw a virtual asset for clients to trade based on the adopted criteria. These criteria and rules must be regularly reviewed by the committee. It must also report at least monthly to the board of directors of the VA trading platform operator, and its reports must at a minimum include details of the virtual assets made available to retail clients for trading. Hong Kong licensed VA trading platform operators are required to monitor each of the virtual assets admitted for trading on an ongoing basis and consider whether to continue to allow them for trading. Regular review reports are required to be submitted to the Token Admission and Review Committee. If the committee decides to suspend or withdraw a virtual asset from trading, the platform operator must notify clients as soon as practicable, inform clients holding that virtual asset of the options available, and ensure that clients are fairly treated. Under the VATP guidelines, a trading platform's senior management is primarily responsible for ensuring that the trading platform and its associated entity have appropriate standards of conduct and procedures in place for their employees, and that employees adhere to those standards and procedures. In particular, senior management is responsible for ensuring that effective policies and procedures are in place to identify and manage the risks associated with the business of the trading platform and its associated entity. The term senior management refers to a platform operator's directors, responsible officers, and managers in charge of core functions. I'm now going to talk about the due diligence that licensed VA trading platform operators are required to perform on all virtual assets they plan to make available for trading, and the specific criteria that must be satisfied for virtual assets that are to be offered for trading by retail investors. The SFC requires licensed VA trading platform operators to perform reasonable due diligence on all virtual assets, irrespective of whether they will be made available to retail clients, before admitting them for trading, to ensure that they meet the token admission criteria established by their token admission and review committees. The non-exhaustive factors that platform operators must consider for all virtual assets include the background of the management or development team of the virtual asset or any of its known key members, the regulatory status of the virtual asset in Hong Kong, and whether its regulatory status would affect the platform operator's regulatory operations, supply and demand for the virtual asset, and its maturity and liquidity, including the length of its track record period, which must be at least 12 months for virtual assets that are not securities. This effectively prevents platforms from offering ICO tokens for trading. Other factors that VA trading platform operators have to consider are the technical aspects of the virtual asset, its development and market and governance risks associated with it, and the legal risks associated with the virtual asset and its issuer. Hong Kong licensed VA trading platform operators intending to make virtual assets available to retail investors must additionally ensure that the relevant virtual assets satisfy the specific token admission criteria set out in paragraphs 7.7 and 7.8 of the VATP guidelines. Retail investors are defined in the guidelines as persons other than professional investors, as defined in the SFO and the Securities and Futures Professional Investor Rules. The key requirement is that the relevant virtual asset must be highly liquid. For a virtual asset to be considered highly liquid, it must at a minimum be an eligible large cap virtual asset. That's a virtual asset that is included in a minimum of 2 acceptable indices issued by at least 2 independent index providers. An acceptable index is an index with a clearly defined objective to measure the performance of the largest virtual assets in the global market. For example, an index which measures the top 10 largest virtual assets, which is investable, which means that the constituent virtual assets must be sufficiently liquid and objectively calculated and rules-based. The index providers must also have the necessary expertise and technical resources to construct, maintain, and review the methodology and rules of the index, which need to be well documented, consistent, and transparent. The 2 index providers have to be independent of each other, the virtual asset trading platform operator and the issuer of the virtual asset. In addition, at least one of the index providers must comply with the IOSCO principles for financial benchmarks and have experience of publishing indices for the conventional securities market. Noting that large market cap does not necessarily correlate with high liquidity, the SFC has said that inclusion in 2 acceptable indices is a minimum criteria, rather than the sole criteria for virtual assets to be eligible for trading by retail investors. Trading platform operators are therefore expected to conduct additional due diligence to ensure that eligible large cap virtual assets admitted for retail trading are in fact highly liquid. Trading platform operators are also required to ensure that a virtual asset to be admitted for retail trading is not a security, as defined in Part 1 of Schedule 1 to the SFO, except where the offering of the virtual asset to retail investors complies with the Hong Kong regulatory requirements for public offers of shares and debentures under the Companies Winding Up and Miscellaneous Provisions Ordinance, and/or doesn't breach the restrictions on offers of investments under Part 4 of the SFO. The SFC's prior written approval is required for the admission of any virtual asset for trading by retail clients and the suspension of trading or removal of any such virtual asset. If a licensed platform operator wants to make available for retail trading a virtual asset that fulfills the general token admission criteria, but not the specific token admission criteria, it can make a submission to the SFC, which the SFC will consider on a case-by-case basis. SFC licensed VA trading platform operators are allowed to provide services to retail investors, provided that they comply with a number of investor protection measures covering client onboarding, platform governance, disclosure, and token due diligence and admission. Under the VATP guidelines, platform operators have to implement a number of measures when serving investors other than institutional professional investors and qualified corporate professional investors. Institutional professional investors are defined in paragraphs A to I of the definition of professional investors in Schedule 1 to the SFO. Qualified corporate professional investors are corporate professional investors, that's a trust corporation, corporation or partnership within sections 4, 6, or 7 of the Securities and Futures Professional Investor Rules, which the licensed platform operator has assessed to meet certain criteria. The first of these criteria is that the corporate professional investor has an appropriate corporate structure and investment process and controls for making investment decisions. The second is that the persons making investment decisions on its behalf have sufficient investment experience, and that the third criteria is that the corporate professional investor is aware of the risks involved, which needs to be considered in terms of the persons who make investment decisions on its behalf. The platform operator's assessment of whether a corporate professional investor is a qualified corporate professional investor must be in writing, and the platform operator must keep records of all relevant information and documents obtained in the assessment to demonstrate the basis of its assessment. Platform operators need to undertake a new assessment if a corporate professional investor has not traded virtual assets for more than 2 years. These provisions mean that platform operators must treat individual professional investors, that's individuals with investment portfolios worth 8 million Hong Kong dollars or more, and corporate professional investors that are not qualified corporate professional investors in the same way as retail investors. Hong Kong licensed VA trading platform operators are not allowed to offer, trade, or deal in virtual asset futures contracts or related derivatives. Some of the key restrictions on licensed virtual asset trading platform operators are that they and their group companies are prohibited from providing any financial accommodation for clients to acquire virtual assets. This prevents them offering margin financing to their clients. Licensed platforms are also prohibited from entering into arrangements with their clients to use clients' virtual assets to generate returns. This prevents licensed trading platform operators from providing services such as earning, deposit taking, lending, and borrowing. They cannot offer clients gifts other than a discount to fees or charges for trading any specific virtual asset, and cannot post adverts for a specific virtual asset. They're also prohibited from providing algorithmic trading services to clients and from conducting proprietary trading for their own account or any account in which they have an interest, except for off-platform back-to-back transactions where no market risk is taken by the platform operator. Licensed platforms are also prohibited from conducting market-making activities on a proprietary basis, and their group companies are prohibited from conducting proprietary trading in virtual assets through the platform operator on or off platform. Platform operators are not allowed to open multiple accounts for a single client except sub-accounts. Platform operators must obtain the SFC's written approval before offering any virtual asset for trading by retail clients and before suspending trading of or removing from trading any virtual asset available to retail clients, that is, non-professional investors. Before opening an account for investors other than institutional professional investors and qualified corporate professional investors, trading platform operators are required to assess their knowledge of virtual assets and of the risks of investing in them. Trading platform operators can only open an account for or provide services to investors who lack knowledge of virtual assets if they've provided adequate training to the investor. The VATP guidelines set out non-exhaustive criteria for assessing whether an investor can be regarded as having knowledge of virtual assets. These are whether the investor has undergone training or attended courses on virtual assets or has virtual asset related work experience or prior trading experience in virtual assets. For clients other than institutional investors and qualified corporate professional investors, VA trading platform operators must also assess clients' risk tolerance level and determine their risk profile and whether they're suitable to trade virtual assets. Client risk profile needs to be determined based on an assessment of their financial situation and investment experience and objectives. Except for institutional and qualified corporate professional investors, VA trading platform operators are also required to set a limit on each client's exposure to virtual assets to ensure that the client's exposure to virtual assets is reasonable given the client's financial situation, including its net worth and personal circumstances. Platform operators will be required to notify these clients of the limit assigned to them and to regularly review clients' exposure limits to ensure that they remain appropriate. When making a recommendation or solicitation with respect to virtual assets, platform operators are required, except when dealing with institutional and qualified corporate professional investors, to ensure the suitability of the recommendation or solicitation for the client is reasonable in all the circumstances, having regard to information about the client of which the platform operator is or should be aware through the conduct of due diligence. Platform operators need to establish a proper mechanism for assessing the suitability of virtual assets for clients. The suitability assessment needs to be made on a holistic basis, taking into account the client's personal circumstances and concentration risk, and the risk-return profile of the recommended virtual asset should match the client's personal circumstances. Except when dealing with institutional or qualified corporate professional investors, trading platform operators must ensure that any transaction in a virtual asset that is a complex product is suitable for the relevant client, even if the transaction has not been recommended or solicited by the platform operator. A complex product is a virtual asset whose features, terms, and risks are not likely to be understood by a retail investor because of its complex structure. The factors to be taken into account in determining whether a virtual asset is a complex product include whether the virtual asset is a derivative product, whether a secondary market is available for the virtual asset at publicly available prices, whether there is adequate and transparent information about the virtual asset available to retail investors, whether there's a risk of losing more than the amount invested, whether any features or terms of the virtual asset could fundamentally alter the nature or risk of the investment or payout profile, or include multiple variables or complicated formulas to determine the return. For example, where the investment carries the right for the issuer to convert it into a different investment, and whether the virtual asset's features might render the investment illiquid, difficult to value, or both. Platform operators also need to provide prominent and clear warnings about complex products before and reasonably proximate to the point of sale for or advice regarding complex products. Except when dealing with institutional and qualified corporate professional investors, VA trading platform operators must take all reasonable steps to prominently disclose the nature of virtual assets and the risks that clients may be exposed to in trading virtual assets on the trading platform. Disclosure must include the risk disclosure statements specified in Schedule 2 to the VATP guidelines. VA trading platform operators are required to disclose a significant amount of information on their websites relating to their businesses and the rights of their clients. The information required to be disclosed includes information about the platform's businesses and the services offered to clients and its contact details. its trading and operational rules, its token admission and removal rules and criteria, including the criteria for admitting, suspending, and withdrawing a virtual asset for or from trading, and the acceptable indices referenced by the platform operator for admitting virtual assets for trading by non-professional investors, and its admission and trading fees and charges. Websites also need to disclose any services that are only available to professional investors, the rights and obligations of the platform operator and the client under the client agreement required to be entered into with clients other than institutional and qualified corporate professional investors, the client's liability for unauthorized virtual asset transactions, its right to stop payment of a pre-authorized virtual asset transfer when the platform operator can disclose the client's personal information to third parties, including regulators and auditors, and the available dispute resolution mechanisms, including the complaints procedure. Licensed platform operators need to post information about each virtual asset traded on their platforms. That information includes the virtual asset's price and trading volume on the platform, for example, in the last 24 hours and since its admission for trading on the platform, background information about the virtual asset's management or development team or any of its known key members, the virtual asset's issue date and its material terms and features, the platform operator's affiliation with the issuer and its management or development team, or any of its known key members, a link to the virtual asset's official website and any white paper, a link to any smart contract audit report and other bug reports of the virtual asset, and where the virtual asset has voting rights, how those voting rights will be handled by the platform operator. Platform operators need to take all reasonable steps to ensure that product-specific and other information posted on their platforms is not false, misleading, or deceptive. They're also required to disclose their financial condition on request to clients by providing their latest audited balance sheet and profit and loss account filed with the SFC and any material changes adversely affecting their financial condition since the date of their accounts. A licensed virtual asset trading platform operator can only hold client assets, that's client virtual assets and client money, through an associated entity. An associated entity is a Hong Kong incorporated subsidiary of the virtual asset trading platform operator, which is a licensed trust or service company provider under the AMLO, which has notified the SFC that it is an associated entity of the licensed virtual asset trading platform operator under Section 53ZRW of the AMLO and Section 165 of the SFO. The associated entity is not allowed to conduct any business other than that of receiving or holding client assets on behalf of the trading platform operator. Client virtual assets must be held in wallet addresses established by the platform operator's associated entity and must be segregated from the assets of the platform operator and its associated entity. At least 98% of client virtual assets must be held in cold storage, which is less vulnerable to hacking and other cybersecurity risks, except in limited circumstances allowed by the SFC on a case-by-case basis to minimize losses resulting from the platform being hacked or compromised. Licensed trading platform operators must have robust internal controls and governance procedures to ensure that cryptographic seeds and private keys are securely generated, stored, and backed up. They must also ensure that their associated entities implement the same controls and procedures, which must, among other things, restrict access to seeds and private keys for client virtual assets to authorized personnel who've been appropriately screened and trained, and provide for seeds and private keys to be securely stored in Hong Kong. Licensed virtual asset trading platform operators must establish a compensation arrangement that is approved by the SFC to cover potential losses arising from, among other things, hacking incidents on the platform or default on the part of the licensed platform operator or its associated entity. The compensation arrangements must cover 50% of client virtual assets held in cold storage and 100% of client virtual assets held in hot and other storages. The compensation arrangement can include any or a combination of third-party insurance, funds held in the form of a demand deposit or time deposit maturing within 6 months of the platform operator or any of its group companies, which are set aside on trust and designated for that purpose, and a bank guarantee provided by a Hong Kong authorized institution, that is, a bank regulated by the HKMA. Licensed platform operators are required to monitor the total value of client virtual assets under their custody daily. If a licensed platform operator becomes aware that the total value of client virtual assets under custody exceeds the amount covered under the approved compensation arrangement, and it expects this to continue, it must inform the SFC and take prompt remedial action to recomply with the VATP guidelines. Platform operators need to use verifiable and quantifiable criteria when selecting an insurance company. These include a valuation schedule of assets insured, maximum coverage per incident, and overall maximum coverage, as well as any excluding factors. VATPs are subject to the AML and CTF requirements of the AMLO, including the customer due diligence and record-keeping requirements set out in Schedule 2 of the AMLO. In the case of non-compliance with the statutory AML and CTF obligations, both the VATP and its responsible officers commit an offence carrying maximum penalties of a 1 million Hong Kong dollar fine and 2 years imprisonment or 7 years imprisonment if the non-compliance is committed with intent to defraud. SFC licensed virtual asset trading platform operators must comply with virtual asset specific AML CTF requirements set out in new Chapter 12 of the renamed Guideline on Anti-Money Laundering and Counter-Financing of Terrorism for Licensed Corporations and SFC licensed VASPs, in addition to the guidelines generally applicable as the AML CTF requirements for licensed entities. The revised and renamed Prevention of Money Laundering and Terrorist Financing Guideline, issued by the SFC for associated entities of licensed corporations and SFC licensed VASPs, requires associated entities of SFC licensed virtual asset trading platform operators to comply with the Guideline on AMLO and Counter-Financing of Terrorism for licensed corporations and SFC licensed VASPs. Financial institutions, which are defined in the AMLO to include virtual asset trading platform operators licensed under the AMLO and/or the SFO, must comply with Section 13A of Schedule 2 to the AMLO, which applies the requirements for wire transfers under FATF Recommendation 16, which is the travel rule, to transfers of virtual assets. Chapter 12 of the Guideline on Anti-Money Laundering and Counter-Financing of Terrorism for licensed corporations and SFC licensed VASPs sets out detailed guidance on the statutory obligation. This requires that when acting as an ordering institution of virtual asset transfers, a licensed platform operator must obtain, record, and submit the required information of the originator and recipient to the beneficiary institution immediately and securely. When acting as a beneficiary institution, a licensed platform operator must obtain and record the required information submitted by the ordering institution or intermediary institution. Licensed platform operators also have to conduct due diligence on virtual asset transfer counterparties, that is, the ordering institution, intermediary institution, or beneficiary institution involved in a virtual asset transfer, to identify and assess the associated money laundering and terrorist financing risks so as to apply risk-based AML CTF measures. Chapter 12 also sets out requirements relating to identifying suspicious transactions and conducting sanction screening of all relevant parties involved in a virtual asset transfer. The travel rule requirements for virtual asset transfers took effect on the 1st of June 2023. However, the obligation on ordering institutions to submit the required information to the beneficiary institution immediately, which means before or when the virtual asset transfer is conducted, has been delayed until the 1st of January 2024. In the interim, the SFC will allow ordering institutions to submit the required information to the beneficiary institution as soon as practicable after the virtual asset transfer, although they must comply with all other travel rule requirements from the 1st of June 2023, including the requirement to submit the required information securely. Licensed VA trading platforms and their associated entities, that is, their Hong Kong incorporated wholly owned subsidiaries that receive or hold client assets, are required to appoint an auditor within 1 month of the grant of the VA trading platform license and file audited financial statements with the SFC within 4 months of the end of their financial year. Corporations licensed under the SFO must also submit monthly financial resources returns to the SFC. Licensed VA trading platforms are also required to notify the SFC of their financial year end within 1 month of the grant of their license. The submission of notifications, regulatory filings, and annual returns should be made through the Wings website. The SFC's prior approval is required for the license changes, including those set out in the table on slides 47 and 48. Application for approval is generally made on Form VA2, except for approval of changes to the licensed entity's substantial shareholders and ultimate owners, for which Form VA4 should be used. The license changes requiring the SFC's approval include a change or waiver of a licensing condition, a change of financial year or the adoption of a period exceeding 12 months as the financial year, the use of new premises for keeping records or documents, cessation of business, and a person becoming a substantial shareholder and/or an ultimate owner of a VA trading platform operator. The SFC must also be given notice of certain events, which are set out on the next 4 slides, within 7 business days. These events include a person ceasing to act as a licensed representative or a responsible officer, a change in the name of a VA trading platform operator, a substantial shareholder or ultimate owner, a change in the business address of a VA trading platform operator or its associated entity, a change in director of the VA trading platform operator or its associated entity or their particulars, and a change in the complaints officer or the emergency contact person or their particulars. Other changes that must be notified to the SFC are any change in the share capital or shareholding structure of the VA trading platform operator, its substantial shareholder and associated entity, and any significant changes in nature of business carried on and types of service provided by the trading platform operator, and any significant changes in its business plan. Changes in managers in charge of core functions or their particulars must also be notified to the SFC, as well as a change in bank accounts, a change of auditor, or of a motion to change the auditor in general meeting. A change in the platform's associated entity or its particulars must also be notified to the SFC, as well as changes to the associated entity's wallet addresses and any change in a trading platform's or licensed representative's authorization to carry on any regulated activity by any authority or regulatory organization in Hong Kong or elsewhere. SFC licensed virtual asset platform operators are responsible for planning and implementing a continuous education program appropriate to the training needs of their licensed employees. Training programs can be designed with reference to the licensed corporation's size, structure, scope of business activities, and risk management system. Licensed platforms should assess their training programs annually to determine whether any adjustments are required. Responsible officers need to complete 12 CPT hours per calendar year, of which 2 CPT hours should cover regulatory compliance topics. Licensed representatives are required to complete 10 CPT hours per calendar year. The guidelines for virtual asset trading platform operators require VA trading platform operators and their associated entities to immediately notify the SFC of various matters. These include any material failure, error, or defect in the operational functioning of the platform operators or its associated entities, trading, custody, accounting, clearing, and settlement systems or equipment, and any material breach or non-compliance or suspected material breach or non-compliance with the SFO, the AMLO, or any SFC rules, regulations, codes, circulars, FAQs, or guidelines, including the VATP guidelines by the platform operator, its associated entity, or any person appointed to conduct business with clients on their behalf. To accommodate this requirement, the SFC has upgraded its existing paragraph 12.5 notifications online portal to enable reports of incidents of material breach and non-compliance to be submitted to the SFC electronically. The SFC must also be notified immediately of any resolution passed, proceedings initiated, or order made which may result in the appointment of a receiver, provisional liquidator, liquidator or administrator, or the winding up, reorganization, dissolution, or bankruptcy of the platform operator, its associated entity, substantial shareholder, or ultimate owner, or any receiving order or arrangement or composition with creditors, the bankruptcy of any director of the platform operator or of its associated entity, and the exercise of any disciplinary measure against the platform operator or its associated entity by any regulatory or other professional or trade body, or the refusal, suspension, or revocation of any regulatory license, consent, or approval required in connection with the platform operators or its associated entity's business must also be notified to the SFC immediately. The AMLO creates various offences in relation to activities in virtual assets that are not securities. Firstly, making a fraudulent or reckless misrepresentation to induce an acquisition or disposal of a virtual asset is an offence, whether the transaction takes place on a licensed VA exchange or not, under Section 537RG of the AMLO. The offence carries maximum penalties of a 1 million Hong Kong dollar fine and 7 years imprisonment. In addition, in a transaction involving virtual assets, it's an offence for a person to employ any device, scheme, or artifice with intent to defraud or deceive or engage in any fraudulent or deceptive act, practice, or business under Section 53ZRF of the AMLO. The maximum penalties for this offence are a Hong Kong dollar 10 million fine and 10 years imprisonment. The maximum penalties for this offence are really quite stringent. It's also an offence for an unlicensed person to issue or possess for the purpose of issue an advertisement which holds the person out as prepared to provide a VA service under Section 537RE of the AMLO. The offence carries sanctions of a 50,000 Hong Kong dollar fine and 6 months imprisonment. Comparable offences exist under the SFO in relation to the same conduct in virtual assets that are securities within the statutory definition. It's an offence under Section 107 of the SFO to make any fraudulent or reckless misrepresentation to induce another person to, amongst other things, deal in securities, which includes acquiring, disposing, subscribing for, underwriting securities. Any person found guilty of an offence under Section 107 of the SFO is liable to a maximum fine of $1 million Hong Kong and up to 7 years imprisonment. It's an offence under Section 300 of the SFO for a person in a transaction involving securities, including an offer or invitation, however that is expressed, to employ any device, scheme, or artifice with intent to defraud or deceive or engage in any act or practice which is fraudulent or deceptive. An offence under Section 300 is punishable by a fine of up to 10 million Hong Kong dollars and imprisonment for up to 10 years by virtue of Section 303 of the SFO. A further offence exists under Section 103 of the SFO, where a person issues, whether in Hong Kong or elsewhere, an advertisement, invitation, or other document containing an invitation to the Hong Kong public to enter into or offer to enter into an agreement to acquire, dispose of, subscribe for, underwrite securities, unless the issue of the advertisement, invitation, or document has been authorised by the SFC under Section 105(1) of the SFO, or an exemption applies. The exemptions most commonly relied on include those for invitations with respect to securities that are or are intended to be disposed of only to professional investors or only to persons outside Hong Kong under Sections 103, 3J and K of the SFO. I'm now going to talk about the SFC's disciplinary powers against licensed VA trading platforms and their officers, which are extensive. The provisions under the AMLO relating to VA trading platforms offering trading in non-security virtual assets have equivalent provisions in the SFO for platforms trading virtual asset securities. Under Section 537SP of the AMLO and Section 194 of the SFC can exercise its disciplinary powers to sanction a regulated person if the person is or was at any time guilty of misconduct or is considered not fit and proper to be or to remain the same type of regulated person. The term regulated person is defined as a person who is or was at the relevant time a licensed VA trading platform, a licensed representative or responsible officer of a licensed trading platform, or a person involved in the management of the business of a licensed trading platform, irrespective of whether that person is licensed. This means that all members of a licensed trading platform's senior management are subject to the SFC's disciplinary powers, even if they're not licensed, because of their involvement in the management of the trading platform's business. Misconduct is defined in Section 53Z SR2 of the AMLO and Section 193 of the SFO to include a breach of any provision of the AMLO or SFO, a breach of the terms or conditions of a person's license, and an act or omission relating to the carrying on of any regulated activity or VA service for which a person is licensed, which, in the opinion of the SFC, is or is likely to be prejudicial to the interest of the investing public or to the public interest. Before forming any opinion for this purpose, the SFC is required to take into account its prevailing codes and guidelines on the matter. In determining whether a regulated person is a fit and proper person for the purpose of considering taking disciplinary action, the SFC can, amongst other things, take into account the past or present conduct of the person. In its FAQs, the SFC gives an example of a situation where the SFC could consider bringing disciplinary proceedings against a manager in charge, the situation where the manager in charge fails to ensure the licensed platform's compliance with the SFC codes and guidelines. As to the sanctions that the SFC can impose against a regulated person, these are set out in Section 53ZSP of the AMLO and Section 194 of the SFO. They include a public or private reprimand and a fine of up to the greater of 10 million Hong Kong dollars or 3 times the amount of profit gained or loss avoided by the person as a result of their misconduct or the conduct which led the SFC to believe that they were not fit and proper to be or to remain the same type of regulated person. The SFC can also revoke or suspend the license of a licensed trading platform or licensed representative and revoke or suspend the approval of a responsible officer. The SFC has the power to order the regulated person to take any action specified by the SFC to remedy the person's breach of the relevant ordinance or their act or omission in carrying on any regulated activity or VA service for which the person is licensed, which the SFC considers to be prejudicial to the public interest. If the person fails to comply with that order, the SFC can fine the person a further 100,000 Hong Kong dollars for each day the failure continues after the deadline for compliance imposed by the SFC. Finally, the SFC can prohibit a regulated person for the duration of a specified period from applying to be licensed or to be approved as a responsible officer. Under the AMLO, the regulated person will be prohibited from applying to be licensed to provide a VA service, while under the SFO, the regulated person will be prohibited from applying to be licensed or registered in relation to a regulated activity or applying to be a responsible officer of an SFC licensed corporation or an executive officer of an SFC registered institution. As regards the SFC's ability to impose fines under Sections 537 SP of the AMLO and Section 194 of the SFO, it has published disciplinary fining guidelines under both ordinances. The guidelines state that the factors the SFC will take into account in determining whether to impose a fine and the amount of a fine include the seriousness of the conduct and whether the person's conduct was intentional, reckless, or negligent. In assessing this, the SFC will give consideration to whether a firm obtained prior advice on the legality or acceptability of the relevant conduct from its advisors, or in the case of an individual, whether they sought such advice from their supervisors or the firm's compliance staff. Other factors the SFC takes into account in exercising its powers to impose fines include whether the person's conduct causes loss to others or benefits to the firm or individual who engaged in that conduct or any other person, and more general factors such as whether the misconduct will cause any reputational damage to Hong Kong. In the case of a licensed VA trading platform, the SFC will also consider whether the misconduct is the result of serious or systemic weaknesses in the firm's management systems or internal controls. The SFC noted in its consultation conclusions on the AMLO disciplinary fining guidelines that it will take into account the level of sophistication of market participants affected by the misconduct, the positions held by the persons who committed misconduct, and the remedial actions taken by those involved, which it says are reflected in the disciplinary guidelines in the specific considerations under the items they refer to as the nature and seriousness of the conduct and other circumstances of the firm or individual. Section 53ZR5 of the AMLO and Section 1932 of the SFO further provide that responsible officers and persons involved in the management of licensed VA trading platforms may also be considered to be guilty of misconduct and thus liable to disciplinary sanction where the licensed VA trading platform operator is or was guilty of misconduct. Responsible officers and persons involved in the management of licensed VA trading platforms will be regarded as guilty of misconduct if the licensed VA trading platform's commission of misconduct occurred with their consent or connivance or was attributable to neglect on their part. Section 53ZTH of the AMLO and Section 213 of the SFO also allow the SFC to apply to the Court of First Instance to make various orders against a person who has breached any provision of the relevant ordinance, any condition of their SFC license, or any other condition or requirement imposed or notice given under any provision of the relevant ordinance. The AMLO additionally allows the SFC to apply for orders against a person who has breached any provision of any code or guideline published under the AMLO, which would include a breach of any provision of the VATP guidelines. The SFC tried to include a similar provision in the SFO when it published its consultation paper on proposed amendments to enforcement-related provisions of the SFO in June 2022, which consulted the market on various amendments to the SFO. The amendment would have allowed the SFC to seek orders, including orders for the payment of compensation, which I'll talk about in a moment, against a person in breach of the various SFC codes, including the Code of Conduct for persons licensed by or registered with the SFC. The SFC, however, dropped that proposal in the face of widespread opposition from the market, which had concerns regarding the courts being able to impose legal remedies for breaches of SFC codes and guidelines, which are non-statutory, and the fairness of the proposed amendment. Under Sections 53ZTH of the AMLO and Section 213 of the SFO, the SFC can seek orders not only against the person who has committed the relevant breach, but also against others who have, for example, assisted or conspired with the wrongdoer to commit the breach, or being knowingly involved in its commission. The orders that the court can impose include an order to freeze the assets of the relevant person and so-called restoration orders. A restoration order is an order for the wrongdoer to restore the counterparties to relevant transactions to the positions they were in before entering into the transactions. There have been a number of cases in recent years where the SFC has been successful in using Section 213 of the SFO to obtain orders freezing the assets of people involved in insider dealing, for example, to ensure that those assets remain available for future restoration orders compensating the victims of the insider dealing. In the landmark Tiger Asia case, which involved insider dealing in the shares of two banks, the court first imposed an injunction freezing the assets of Tiger Asia and three of its senior officers, pending the grant of the final orders. It then ordered the unwinding of transactions between Tiger Asia and 1,800 sellers of the bank's shares, and ordered Tiger Asia and two of its senior officers to pay around $45.3 million to the sellers to restore them to the position before the share sales to Tiger Asia. This was the first time the SFC obtained a restoration order for insider dealing to compensate investors for losses resulting from insider dealing. Since the Tiger Asia decision, Section 213 has become the SFC's weapon of choice for obtaining investor compensation in insider dealing and other market misconduct cases. Other orders that can be imposed by the Court of First Instance include injunctions prohibiting the contravening conduct, orders appointing an administrator of a person's property, orders declaring a contract relating to virtual assets to be void, and ancillary orders. The SFC has broad powers under the SFO and AMLO to enter the business premises of licensed VA trading platforms and their associated entities to conduct routine inspections, request production of documents and records, investigate breaches, and sanction licensed persons involved in the breaches. Possible sanctions include a reprimand, an order for remedial action, a fine, and suspension or revocation of a person's license. The SFC can also appoint an auditor to conduct an investigation into the affairs of a licensed VATP and its associated entities, where it has reason to believe that there's been a breach of the AMLO or any code or guideline published under it. The SFC also has intervention powers to impose restrictions and prohibitions on the operations of a licensed VATP and its associated entity in certain circumstances, for example, where it's necessary to protect client assets. The AMLO licensing regime for virtual asset trading platform operators trading virtual assets that are not securities commenced on the 1st of June 2023. From then, any unlicensed virtual asset trading platform trading non-security virtual assets and carrying on business in Hong Kong or actively marketing its services to Hong Kong investors breaches the licensing requirements under the AMLO licensing regime. However, there were transitional arrangements which allowed virtual asset trading platforms trading non-security tokens which operated and had a meaningful and substantial presence in Hong Kong before 1st of June 2023 to continue to operate in Hong Kong without a license until 31st of May 2024. When considering whether a VA trading platform had a meaningful and substantial presence, the SFC considered, amongst other things, whether it was incorporated in Hong Kong, whether it had a physical office in Hong Kong, whether its central management and control and key personnel were based in Hong Kong, and whether the trading platform was live with a considerable number of clients and volume of trading transactions in Hong Kong. Operators of pre-existing trading platforms which applied online for a license under the AMLO between the 1st of June 2023 and the 29th of January 2024 and met certain conditions were also eligible to be deemed to be licensed from June 2024 until the earlier of the approval, withdrawal, or refusal of their license application. However, that deeming arrangement did not automatically apply to all trading platforms that applied for a license under the transitional arrangements before the 29th of February 2024 deadline. If the SFC considered that a platform did not satisfy the relevant legal and regulatory requirements or didn't have a reasonable prospect of demonstrating compliance with those requirements, it could give notice to the trading platform that the deeming provision would not apply to it. The platform would then have to close down its business by May 2024 or within 3 months of the date of the SFC notice, whichever was the later. Similarly, provisions applied to individuals performing regulated functions for a virtual asset trading platform operating in Hong Kong before 1st of June 2023. They could continue performing regulated functions without a license and are subject to a deemed licensing arrangement from the 1st of June 2024 until their license application is actually approved or rejected, or they withdraw their application. The period for applying under the transitional arrangement has ended now. This means that platforms that were operating in Hong Kong under the transitional arrangements but failed to submit a license application to the SFC by the end of February 2024 were required to close down their Hong Kong businesses by the end of May 2024. If they haven't done so, they will be committing the offence of carrying on business as a virtual asset service provider without a license. The end of the transitional period also means that the only virtual asset trading platforms that are currently allowed to operate in Hong Kong are the 2 formally licensed platforms, OSL and Hashkey, and the 11 virtual asset trading platforms that are deemed to be licensed, which are waiting to hear whether their license will be granted or not. Other entities that have submitted a license application but can't rely on the deeming arrangements can't operate a virtual asset trading platform in Hong Kong or actively market its services until their license is granted. The SFC issued a statement in May 2024 on the consequences of the end of the transitional period, warning investors that platforms that, as of the 1st of June 2024, are deemed to be licensed are not the same as SFC licensed platforms. In their licensing applications, these platforms undertook to implement policies, procedures, systems, and controls to comply with the regulatory requirements. As we saw earlier, they also had to appoint external assessors to produce a final report on the implementation and effectiveness of those policy, procedures, systems, and controls. The SFC noted in the May statement that it would conduct on-site inspections to ensure that platforms operating under the deemed licensing provisions comply with its regulatory requirements, particularly in relation to protecting client assets and the conduct of Know Your Client processes. It said these on-site inspections would inform the licensing process, and any material non-compliance with its requirements would result in the SFC rejecting the licensing application. In short, therefore, investors need to be aware that trading on trading platforms that are operating under the deemed to be license arrangements is not without risk. Although they're required to comply in full with the SFC's regulatory regime, there's no guarantee that they are in fact doing so. Their applications for a license may still be rejected, and they will then have to close down. The SFC will then ask the trading platform to provide a plan setting out how it will ensure that its Hong Kong business is wound down in an orderly manner and how it will protect client assets. The advice from the SFC is therefore that investors should only trade virtual assets on fully licensed platforms and recommends that they consult the list of licensed platforms available on its website. The SFC's May 2024 statement also contained various reminders for platforms operating under the deemed licensing provisions after the 1st of June 2024. First, they must comply with all the regulatory requirements and licensing conditions set by the SFC. Also, they're not allowed to actively market their services or accept new retail clients until the SFC is satisfied with the actual implementation and effectiveness of their policies, procedures, systems, and controls, and they are formally licensed. Platforms operating under the deemed provisions and their ultimate owners are required to comply with all applicable laws and regulations. In particular, deemed licensees are required to prevent mainland Chinese residents from accessing any of their virtual asset related services and to ensure that their controlling entities and related parties do the same. Since the period for applying under the transitional arrangements has expired, any entity wanting to provide virtual asset trading services in non-security virtual assets in Hong Kong must apply to the SFC for a license under the AMLO and can't provide those services until the license has been granted. There were no transitional arrangements under the SFO. As before, virtual asset trading platforms intending to offer trading in security tokens need to be separately licensed under the SFO for Type 1, that is, dealing in securities, and Type 7, providing automated trading services, regulated activities, before they commence operations in Hong Kong. On the 29th of September 2023, the SFC announced its publication of lists of virtual asset trading platforms on its website, disclosing the licensing status of various VATPs operating in Hong Kong or actively promoting their services to investors in Hong Kong. 5 lists have been published: a list of licensed virtual asset trading platforms, a list of applicants for virtual asset trading platform licenses, a list of applications whose applications have been returned, refused, or withdrawn, a list of closing down virtual asset trading platforms, and a list of suspicious virtual asset trading platforms. The SFC advises investors to verify the license status of VATPs by reference to its list of licensed platforms and to be wary of the risks of investing with unregulated VATPs. However, it notes that while it will update the lists regularly, they may not be completely up to date, as changes to the regulatory status of trading platforms may occur between updates. The SFC's list of licensed virtual asset trading platforms sets out the names of platform operators that are licensed by the SFC to offer trading in virtual assets. At the moment, there are still only 2 virtual asset trading platforms which are formally licensed by the SFC, as I mentioned earlier, OSL and Hashkey. Investors can access detailed information about licensed platforms, including the regulated activities they're licensed for, their business address, the names of their ROs, licensed reps, and complaints officer, the conditions attached to their license, and public disciplinary actions against them in the past 5 years. Trading platforms' previous names and their past license records are also available. These details can also be accessed through the SFC's public register of licensed persons. Licensed applicants will be transferred to this list from the list of VATP applicants if their licensing applications are successful. The SFC reminds investors that this list only confirms that the VA trading platforms are formally licensed by the SFC, and that the SFC does not guarantee the performance or creditworthiness of any SFC licensed VA trading platform. The second list of virtual asset trading platform applicants sets out the names of trading platform operators that have applied to the SFC to be licensed and are waiting for their applications to be approved. As at the 2nd of September, there were 17 virtual asset trading platform applicants. These include 11 which are deemed to be licensed under the transitional arrangements I just talked about. For the reasons I just described, the SFC's webpage of lists appears with a banner warning investors that they should only trade virtual assets on licensed platforms, and that their platforms that are deemed to be licensed are not formally licensed by the SFC. These are virtual asset trading platforms that are transitional arrangements have allowed to operate in Hong Kong under a deemed license from the 1st of June 2024 until their licensing applications are approved, rejected, or withdrawn. The SFC, however, warns the public that the fact that a platform is deemed to be licensed doesn't mean that it complies with the requirements for licensing or that it will be granted a license in future. The SFC's aim in publishing the list of licensed applicants is to allow investors to check whether a VA trading platform has applied to be licensed and verify the accuracy of claims it has made to have applied for licensing. However, the SFC makes clear that licensed applicants on this list have not yet licensed or regulated by the SFC, and that their presence on the list does not mean that they comply with the AMLO's regulatory requirements. It's also important to note that the other 6 license applicants on the list are not deemed to be licensed under the transitional arrangements. They're not allowed to operate a virtual asset trading platform until they've been formally licensed by the SFC. If they commence operations before they're licensed, they would commit a criminal offence under the AMLO and/or the SFO. As regard the list of applicants whose license applications have been returned, refused, or withdrawn, the SFC will return an application that's incomplete, for example, one that fails to submit all the required information and documents, including external assessment reports, or if there are unresolved fundamental issues in the eyes of the SFC. The SFC will also refuse a license applicant that it does not consider to be fit and proper to be licensed. As at the 2nd of September 2024, 12 virtual asset trading platform operators have withdrawn their license application and 1 has been returned. The list of closing down VA trading platforms sets out the names of platforms that are required to close down by law within a specified period. When a trading platform is closed down, it cannot provide any services unless the operations facilitate the closing down of its business. During the closing down period, all marketing activities targeting Hong Kong investors are required to cease. The SFC's list of suspicious virtual asset trading platforms is a list of entities which have come to the attention of the SFC because they're unlicensed in Hong Kong and are believed to be or to have been targeting Hong Kong investors or claiming to have an association with Hong Kong. The SFC is encouraging anyone who has been contacted by an unlicensed firm to notify the SFC by completing a complaint form on the SFC's website. There were no names on this list at the 2nd of September 2024. So that brings us to the end of the regulatory regime for virtual asset trading platforms under the SFO and AMLO. I'm now going to move on to some of the developments since the implementation of the AMLO regime, in particular the fallout from the JPEX case, which came against the background of the trial in the US of Sam Bankman-Fried, founder of failed crypto exchange FTX. I will also be looking at some of the more recent warning statements issued by the SFC. All these cases make a fairly convincing argument for regulation. The SFC issued its first major warning statement on the 7th of August 2023, entitled Warning, Virtual Asset Trading Platforms Engaged in Improper Practices Warning. Unlicensed virtual asset trading platforms are the potential legal and regulatory consequences of false claims to have applied for SFC licensing and providing prohibited services such as virtual asset deposit taking, paying a return to depositors. The statement also warned investors of the risks of trading crypto on unlicensed exchanges, which may not comply with Hong Kong's regulatory requirements for licensed virtual asset trading platforms. As I mentioned earlier, Hong Kong currently only has 2 licensed trading platforms. According to the warning statement, which was issued during the transitional period, some unlicensed trading platforms operating in Hong Kong claim to have submitted a licensing application to the SFC, which the SFC said was not true. According to the SFC, these platforms risk committing an offence under Section 537RG of the AMLO, which, as I discussed earlier, is the offence of making a fraudulent or reckless misrepresentation in order to induce an acquisition or disposal of a virtual asset. According to the SFC, false claims to have applied for SFC licensing can mislead the investing public into believing that the crypto exchange complies with the regulatory requirements for licensing, when this is not the case. If the exchange subsequently applies for a license, the SFC said that it will take any misrepresentation as to the exchange's license status into account in determining its fitness and properness to be licensed. The SFC's August 2023 warning statement also noted that some unlicensed trading platforms had tried to take advantage of the AMLO's transitional arrangements. Some unlicensed platforms apparently set up new entities to provide virtual asset services in Hong Kong before the 1st of June 2023 and announced their intention to apply for licenses for these new entities. As we saw earlier, trading platforms with a substantial presence in Hong Kong before the 1st of June 2023 could continue their operations without a license until the 31st of May 2024 without breaching the AMLO. However, they had to apply for a license under the AMLO by February the 29th, 2024 to be able to continue operating under a deemed license from the 1st of June 2024 until the final determination of their license application. The SFC therefore warned investors that they needed to be aware that exchanges that claim to have submitted a license application may not in fact have done so and may not be complying with the AMLO's requirements. In fact, before a trading platform relying on the transitional provisions became deemed to be licensed on the 1st of June 2024, it was under no obligation to comply with the AMLO's regulatory regime. It only had to confirm in its license application that on being deemed to be licensed on the 1st of June 2024, it would comply with the regulatory regime for licensed virtual asset trading platforms. However, the SFC may refuse to grant a platform a license if the SFC does not consider it to be fit and proper. For example, if it conducts activities that are prohibited under the AMLO. The SFC stated in the warning statement that some unlicensed trading platforms were offering services and products that do not comply with the applicable legal and regulatory requirements. These included offering retail investors virtual assets that are unsuitable for retail trading, offering services in virtual asset derivatives, and offering products such as virtual asset deposits, savings, or earnings, all of which are prohibited under the AMLO regime. The SFC warned that in assessing VATP's licensing applications, it would take into account any previous non-compliant activities that could have been avoided. Specifically, the SFC viewed that it would take a negative view of non-compliant activities that result in client transactions having to be unwound or a virtual asset being removed from retail trading, if that could have been avoided. Separately, in assessing these platforms' licensing applications, the SFC would also consider whether the platforms genuinely intend to rectify non-compliant activities and unwind prohibited transactions in an orderly manner. The warning statement also reminded unlicensed crypto exchanges that were not eligible to apply under the transitional arrangements that they cannot operate in Hong Kong until they've applied for and been granted a license by the SFC. It also warned investors that with the exception of platforms on the SFC's list of licensed virtual asset trading platforms, none of the virtual asset trading platforms accessible by the public were in Hong Kong, are regulated by the SFC. The SFC warned investors to be wary of the risks of trading virtual assets on an unregulated trading platform and that they could risk losing their entire investment held on the platform if it ceases to operate, collapse, is hacked, or its virtual assets are otherwise misappropriated. The SFC is closely monitoring unauthorized crypto products being offered to the Hong Kong public and crypto-related activities conducted by entities that are not regulated by the SFC. This can be seen from its listing of 42 crypto businesses on its suspicious virtual asset trading platforms alert as at the 2nd of September 2024. The SFC has issued warning statements to the public relating to each business listed, setting out the virtual asset-related fraud and/or false claims of regulated virtual asset trading platform status allegedly involved. The SFC advises investors to check its list of licensed virtual asset trading platforms available on the SFC website to ascertain whether trading platforms are in fact regulated and monitored by the SFC. As you'll see if you go to the lists, there's a banner warning across the page advising investors to only trade on licensed platforms. I'm just going to look at a few of these to give a flavour of the types of activities being conducted apparently in breach of Hong Kong's regulatory regime for virtual assets. In July 2024, the SFC issued warning statements to the public regarding 9 entities suspected of engaging in fraudulent activities purported to be related to virtual assets. These included entities such as XT, CQT, CEG, BTE Pro, Bittones.org, Yomex, BStore, TaurusMex, Proxinex, and CoinUnited.io. According to the SFC, these entities purported to provide cryptocurrency trading services, and some of them employed social media platforms or instant messaging apps to refer investors to their respective websites to register for investing in cryptocurrencies. Yet none of these entities are licensed by the SFC, nor have they applied to the SFC for a license. Investors had encountered problems withdrawing their assets from these entities. In some cases, the entities suspended withdrawals on the pretext that the investors' accounts involved money laundering activities or illegal funds. In the case of Proxinex, investors were told that their accounts did not exist at all when they tried to withdraw their virtual assets, and it's suspected that Proxinex's agent had fabricated documents purportedly issued by a local financial regulator and a financial institution to give the platform a semblance of legitimacy. Investors were required to pay exorbitant fees or tax for withdrawals or reactivation of suspended accounts. One of the suspected entities, TaurusMax, also apparently falsely claimed that investors' accounts were regulated by the SFC. On the 21st of August 2024, the SFC also issued a warning statement regarding ICE Global Professional Station, which apparently claimed to be a digital asset trading platform. It's suspected of being involved in virtual asset-related fraud, with investors reporting difficulty in withdrawing funds after making deposits for investments in cryptocurrency products. So turning now to JPEX, which was no doubt one of the crypto exchanges the SFC was alluding to in its August 2023 warning statement. In an incident involving the unlicensed crypto exchange JPEX, the Hong Kong police reportedly arrested over 70 people linked to suspected fraud. Allegedly, more than 2,600 victims suffered losses exceeding 1.6 billion Hong Kong dollars. The accusations against JPEX include false regulation claims and engagement in activities prohibited by the AMLO regulatory regime. The SFC initiated an investigation in March 2022, escalated their warnings after JPEX failed to cooperate, and issued 9 alerts across various platforms. In September 2023, the SFC publicly denounced JPEX for false regulatory claims and prohibited activities, prompting police involvement due to suspected fraud. The SFC issued warnings in 2023 about JPEX regarding its false claims about its regulatory status and engagement in deceptive practices. JPEX falsely claimed to be regulated by various overseas authorities and to have a partnership with a legitimate entity. It also offered unrealistically high returns on virtual assets, potentially breaching guidelines which prohibit even licensed virtual asset trading platforms from using clients' virtual asset to generate returns for their clients. Customers also reported difficulties withdrawing assets and increased withdrawal fees. According to the SFC, various other parties, including social media influencers, key opinion leaders, and over-the-counter virtual asset money changers, had actively promoted JPEX's products and services to the Hong Kong public. They'd also allegedly made false or misleading statements on social media, suggesting that JPEX had applied for a VATP license in Hong Kong. The SFC's statements warned investors of the risks of trading virtual assets on unregulated crypto exchanges and highlighted the difficulty of seeking recourse against and obtaining legal remedies from exchanges that have no nexus with Hong Kong. It advised investors to check the licensing status of exchanges on the SFC's list and cautioned against relying on social media investment advice. If the allegations against JPEX and the various third parties referred to in the warning statement are substantiated, the AMLO provisions that may have been breached include Section 53ZRF of the AMLO, which, as we saw earlier, makes it an offence to directly or indirectly employ any device, scheme, or artifice with intent to defraud or devise or engage in any act, practice, or course of business that is fraudulent or deceptive, or would operate as a fraud or deception in a transaction involving virtual assets. The other potential offence to which the SFC warning statements refer is the offence under Section 537RG of the AMLO, which makes it an offence for a person to make a fraudulent or reckless misrepresentation to induce another person to enter into or offer to enter into an agreement to acquire, dispose of, subscribe for, underwrite virtual assets. For a statement to be a fraudulent misrepresentation, the person making it must know that it is false or misleading. Both offences carry custodial sentences of up to 10 years imprisonment in the case of Section 53ZRF and up to 7 years imprisonment in the case of Section 53ZRG. As we saw earlier, Section 53ZTH of the AMLO and Section 213 of the SFO also allow the SFC to apply to the Court of First Instance for various orders against those who've breached the provisions of the ordinance, and in the case of the AMLO, those who breach any provision of the VATP guidelines. JPEX and those who conspired or were knowingly involved in its breach of the AMLO and the VATP guidelines, if proven, may therefore be ordered under these provisions to compensate any victims of JPEX's non-compliant activities. In a sign that the SFC plans to enforce the virtual asset licensing regime strictly, the SFC said in its warning statements regarding JPEX that it will not hesitate to bring enforcement action against individuals and entities that breach the provisions of the VATP licensing regime, including those who are involved in any contravention. Although there's been no official statements of the offences with which individuals involved in the JPEX case have been charged, media reports suggest that they were arrested on charges of conspiracy to defraud. On the 4th of October 2023, the SFC announced its establishment of a joint working group with the Hong Kong police after a high-level meeting on the 20th of September 2023. The working group is made up of representatives from Hong Kong Police Force's Commercial Crime Bureau, its Cybersecurity and Technology Crime Bureau, and its Financial Intelligence and Investigations Bureau, and from the SFC's Enforcement and Intermediaries Division. The mission of this group is to facilitate the exchange of information regarding suspicious activities and VA trading platforms breaches of the applicable regulatory regime and to improve coordination and collaboration in investigating illegal activities. On the 25th of September 2023, the SFC announced that it's working with the Investor and Financial Education Council to educate and warn investors about the risks of trading virtual assets on unregulated platforms. These initiatives include the publication of the various lists I talked about. The SFC is also proposing to launch a public campaign to raise investor awareness of the risks associated with virtual assets and the potential for fraud through education talks and through the media and social media. These developments indicate that Hong Kong regulators appear very willing to enforce the provisions of Hong Kong's virtual asset trading platform regulatory regime against those who contravene its requirements. So that brings us to the end of this long presentation. Thank you again for joining me. I hope you found the webinar useful and look forward to seeing you again. Bye.